You all may be seated. Okay, are we ready to proceed?
Yes, Your Honor.
Okay. Are there any representations that you'd like to make?
Your Honor, it is my understanding that Mr. Redden is going to plead guilty but mentally ill to all of the charges in the second amended indictment that was previously filed. The state is willing to stipulate to allow him to withdraw his prior pleas of guilty so that he can enter pleas of guilty but mentally ill to counts 2 through 7. And he's also pleading guilty but mentally ill to count 1.
And that's our understanding, Your Honor, and he's prepared to go forward with the plea agreement.
Okay. All right.
But in terms of the negotiations, Your Honor, there are no negotiations. Each side will argue for a lawful sentence under the statute.
Okay. All right. Mr. Redden?
Yes.
I'm going to be asking your lawyer to state in open court the substance of the plea agreement. In other words, the primary, the most important terms of the negotiations or agreement between you and the state. Actually, this is a guilty plea memorandum.
Correct.
Okay. I want you to listen carefully, as after your lawyer's done speaking, I'm going to ask you if you heard him and if you agree that this is what the parties have agreed to enter into. All right?
Okay.
Okay. Mr. Arnold?
Your Honor, he's agreed to plead guilty but mentally ill to count 1, attempted murder, victim 60 years of age or older. Count 2, battery on a protected person, resulting in substantial bodily harm, victim over 60 years of age or older. Count 3, intimidating a public officer. Count 4, battery on an officer resulting in substantial bodily harm. Count 5, performance of act or neglect of duty in willful or wanton disregard of safety of persons or property, resulting in substantial bodily harm or death. Count 6, battery by prisoner. Count 7, unlawful act related to human excrement or bodily fluid.
Okay. And this is what I will do. Once I canvass Mr. Redden, I will go ahead and allow him to withdraw his guilty plea with respect to the counts 2 through 7.
Thank you, Your Honor.
Did I get the numbers right?
Yes.
Yes.
Okay. All right. Mr. Redden,
Yes.
did you hear your lawyer just state the substance of the guilty plea memorandum?
Yes.
Okay. Did he accurately state the terms that you had agreed in order to resolve the criminal charges lodged against you?
Yes.
Do you read, write, and understand the English language?
I do.
Okay. Did you receive a copy of the guilty plea memorandum?
I did.
Did you review the second amended indictment?
Yes, I did.
Okay. Did you receive a copy of that as well?
Yes.
Okay. Do you need me to read the second amended indictment now before we take your plea?
No.
Okay. Before accepting your guilty plea, there's a number of questions I'm going to have to ask you in order to assure me you are entering a valid plea. If you do not understand any of my questions, will you please let me know so that I can rephrase them?
I will.
If at any time you wish to take a break in the proceedings so that you can discuss matters in private with your lawyer, will you let me know so that I can give you an opportunity to do so?
Yes.
How old are you, sir?
I'm 31.
Where were you born?
Las Vegas, Nevada.
What is the extent of your education?
12.
Did you graduate from high school?
No.
Would it be fair to say you dropped out in the 12th grade?
Yes.
Okay. You finished the 11th grade?
Yes.
Okay. Are you taking any medications or suffering from any medical, physical, or mental health conditions that would interfere with your ability to understand these proceedings and the terms of the guilty plea memorandum?
I am on mental health meds, but as long as I'm on that, I don't believe that it'll affect any of my
Okay.
just understand.
Well, I know that you've got to be on some medication, sir. I think we've been discussing that here today. But I want to know, are you taking any medications or suffering from any medical, physical, or mental health conditions that would interfere with your ability to understand what is going on here today or the terms of the guilty plea memorandum?
Oh, no.
You fully understand?
Yes.
Have you had an ample opportunity to discuss your case with your lawyer, Mr. Arnold?
Yes.
Are you satisfied to have him as your lawyer and the advice that he has given to you?
Yes.
Do you understand you are entitled to have an attorney represent you at every stage of the proceeding lodged against you?
Yes.
Do you understand you're entitled to a trial by jury, at which in order to convict you, all of the jurors would have to agree that you are guilty?
Yes.
Do you understand at trial you would be presumed to be innocent, and the state would have to overcome that presumption and prove you guilty beyond a reasonable doubt?
Yes.
Do you understand that to do this, the witnesses for the state would have to come to court and testify in your presence, and your lawyer could cross-examine those witnesses?
Yes.
Do you also understand that your lawyer could object to evidence offered by the state at the trial and could call witnesses and present evidence on your behalf?
Yes.
Do you understand at trial, while you have the right to testify if you chose to do so, you also would have the right not to testify, and if you decided not to testify at your trial, the state would not be able to use the fact you did not testify in any way to prove its case?
Yes.
Do you understand that by entering your guilty pleas, you are giving up these rights and other rights listed in the guilty plea memorandum?
Yes.
Are you aware of the penalties for committing the crimes which are listed in count 1 through count 7?
Yes.
I'd like to review all of them with you. This will take a little bit of time, but I want to make sure you understand, okay? Do you understand, as a consequence of entering a plea of guilty but mentally ill, you have the burden of establishing your mental illness by a preponderance of the evidence?
Oh, yes.
Do you understand that except as otherwise provided by specific statute, as a defendant who has entered such a plea, you would be subject to the same criminal, civil, and administrative penalties and procedures as a defendant who regularly just pleads guilty?
Wait, say that one.
Sure. Do you understand, except as provided by specific statute, as a defendant who has entered a plea of guilty but mentally ill, you are subject to the same criminal, civil, and administrative penalties and procedures as a defendant who pleads guilty?
Yes.
Okay. Okay, do you understand that if the court finds by a preponderance of the evidence you are not mentally ill at the time of sentencing, that the court may impose any sentence that the court is authorized to impose upon a defendant who pleads or is found guilty of the same offense, or that you are mentally ill at the time of or if you are mentally ill at the time of sentencing, the court shall impose any sentence the court is authorized to impose upon a defendant who pleads or is found guilty of the same offense, and include in that sentence an order that you, during the period of your confinement or probation, be given or obtain such treatment as is medically indicated for your mental illness. Do you understand that?
Yes.
That's all set forth on page 2 of the guilty plea memorandum.
Mm-hmm.
Okay, do you understand that as a consequence of your plea of guilty but mentally ill, the court must sentence you as follows? First, with respect to count 1, the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 20 years, plus a consecutive sentence of 1 year to 20 years for the age enhancement. Do you understand that?
Yes.
Do you understand the minimum term of imprisonment may not exceed 40% of the maximum term of imprisonment?
Yes.
Do you also understand that you also may be fined?
Yes.
Okay. Do you understand that you are eligible for probation for the offense to which you are pleading guilty?
Yes, I understand.
Do you also understand, except as provided by statute, the question of whether you receive probation is in the discretion of the sentencing judge?
Yes.
With respect to count 2, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years, plus a consecutive sentence of 2 years, minimum 2 years to 10 years for the age enhancement?
Yes.
Do you, again, as with count 1, do you understand that the minimum term of imprisonment may not exceed 40% of the maximum term of imprisonment?
Yes.
Do you also understand in that situation you may also be fined for that?
Yes.
And as like count 1, do you also understand you are eligible for probation for the offense to which you are pleading guilty, meaning count 2?
Yes.
With respect to count 3, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 5 years?
Yes.
Do you also understand that you could be fined up to $10,000?
Yes.
And as with respect to counts 1 and 2, the minimum term of imprisonment may not exceed 40% of the maximum term of imprisonment.
Yes.
And I might save a little bit of time, but the minimum term of imprisonment may not exceed 40% of the maximum term of imprisonment would also apply to counts 4, 5, and 6, and 7. Do you understand that?
Yes.
Okay. And you also understand that you are eligible for probation with
Yes.
respect to those other counts,
Yes.
as well as count 3.
Yes.
Your Honor, I think count 7 is actually non-probationable.
Okay. Okay. I will get to count 7. I thank you, counsel, for doing that. You are not eligible for probation with respect to count 7. We will get to that in a few moments. Do you understand that?
Yes.
Okay. With respect to count 4, do you understand the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years?
Yes.
Do you understand in that instance you may be fined up to $10,000?
Yes.
With respect to count 5, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 5 years?
Yes.
Do you also understand you could be fined up to $10,000 with respect to that count?
Yes.
With respect to count 6, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 6 years?
Yes.
Do you also understand in that instance you could be fined up to $5,000?
Yes.
Okay, and that again is with respect to count 6. With respect to count 7, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years?
Yes.
Okay, and you do understand that you are not eligible for probation for the offense to which you're pleading guilty with respect to count 7?
Yes.
And do you understand you could also be fined up to $10,000?
Yes.
And in any case, that the law does require you to pay certain administrative assessment fees.
Yes.
Do you also understand the court may order you to make restitution to any victim of the offense to which you are pleading guilty?
Yes.
Has anyone threatened you or forced you to plead guilty but mentally ill?
No.
Has anyone told you if you do not plead guilty but mentally ill, some other adverse action will be taken against you?
No.
And I take it that you have you've received a copy of the guilty plea memorandum,
Yes.
okay? And your signature is affixed thereon on page 8, is that right?
That's true.
And your lawyer, Mr. Arnold, he signed the guilty plea memorandum on page 9?
Yes.
Prior to signing the guilty plea memorandum, did you read it?
Yes, I did.
Did you discuss it with your lawyer before you signed it?
Yeah, I did.
Did he answer all of your questions?
Yes, he did.
Did you sign the guilty plea memorandum willfully, knowingly, and voluntarily?
Yes.
Do you feel you understand the terms of the guilty plea memorandum?
I do.
Has anyone made any promise to you other than those set forth within the guilty plea memorandum that induced or caused you to plead guilty but mentally ill?
Say that one more time, sorry.
Sure. Has anyone made any promise to you other than those set forth within the guilty plea memorandum that induced or caused you to plead guilty but mentally ill?
No.
You understand that later on, when there are requests with respect to sentences or any sentences that may be agreed to by your lawyer, and the lawyers for the state would not be binding upon the sentencing judge.
I don't understand what that means.
Do you understand that sentencing is totally up to me?
Okay, yes.
That's irrespective of whatever your attorney argues to me. If later on there's deals made between your lawyer and the lawyers for the state, I don't have to abide by those deals. You understand that?
Yes.
Okay. And do you also understand that you might, on the basis of your guilty plea but mentally ill, receive, if there was any deals going on, that you could receive a more severe sentence than that, either requested, recommended, stipulated, argued by your lawyer?
Yes.
Okay. Do you have any questions as to what you're alleged to have done within the second amended indictment?
No.
Do I need to review all that with him?
He's never been canvassed as to count one, Your Honor. I think the parties can agree to incorporate the factual basis from his previous plea as to counts 2 through 7, but he's never been canvassed as to count one.
Okay, let me go through that. I don't have that right in front of me, so let me pull it up. I'm going to go through all the counts.
Thank you, Your Honor.
Okay. Okay, I'm looking at the, well, it's called the amended indictment. And it was filed on August 30th.
It's the second amendment that was filed on Tuesday, Your Honor. That's the charging document we're going off of.
Okay. Okay, I need it. Yeah, apparently it was filed in open court, counsel, and for whatever reason, hasn't made it yet, but they're going to do it like right this minute. I'm going to email them right now, Your Honor.
I can email the court a copy if you want to read them electronically.
If you got a file stamp on it, I'd be happy to do that.
Let me see if I can. Let's see if you want a copy.
In fact, counsel, would you approach? Okay, I've got it, Miss Mercer.
Thank you.
Okay. Okay, Mr. Redden?
Yes.
She's got a copy that is file stamped, well, it's not file stamped, but it is the one that was filed. I'm going to go ahead and review the second amended indictment with you, if I may, and tell me if this is what you did. And again, you're pleading guilty but mentally ill. I appreciate that, so I may not add all of that. Okay, tell me if this is what you did with respect to count 1, attempt murder, victim 60 years of age or older, that you willfully, unlawfully, and feloniously, and with malice aforethought, attempt to kill Judge Mary Kay Holthus, who is 60 years of age or older, to wit, during your rendition of sentence, and once you knew she was about to sentence you to prison, did leap over defense counsel's table into the well of the courtroom, and thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary Kay Holthus's judicial space, landing directly on top of her and immediately attacking Judge Mary Kay Holthus by grabbing her, pulling her hair, placing your hands around her throat, and or hitting her on the head by manner and means unknown. Did you do that, sir?
Yes.
Okay. With respect to count 2, tell me if this is what you did. That, and by the way, this is on or about January 3rd, 2024 in Clark County, Nevada. That with respect to battery on protected person resulting in substantial bodily harm, victim over 60 years of age or older, that you did willfully, unlawfully, and knowingly use force or violence upon the person of another, to wit, Judge Mary Kay Holthus, who is 60 years of age or older and is a protected person employed as an 8th Judicial District Court judge while Judge Mary Kay Holthus was performing the duties of an 8th Judicial District Court judge, which you knew or should have known that Judge Mary Kay Holthus was an 8th Judicial District Court judge by grabbing her, pulling her hair, placing your hands around her throat, and or hitting her on the head by manner and means unknown, resulting in substantial bodily harm to Judge Mary Kay Holthus. Did you do that, sir?
Yes.
Okay, with respect to count 3, intimidating public officer, that on the same date, place, and time, that tell me if this is what you did, that you did willfully, unlawfully, and feloniously, directly or indirectly, address any threat or intimidation to a public officer, namely Judge Mary Kay Holthus, a judicial officer with intent to induce her, contrary to her duty to do, make, omit, or delay any act, decision, or determination with use of physical force or the immediate threat of such force, to wit, during the rendition of sentence, and once you knew she was about to sentence you to prison, did leap over defense counsel's table into the well of the courtroom, thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary Kay Holthus's judicial space, landing directly on top of her and immediately attacking Judge Mary Kay Holthus by grabbing her, pulling her hair, placing your hands around her throat, and or hitting her on the head by manner and means unknown. Did you do that, sir?
Yes.
Count 4, battery on an officer resulting in substantial bodily harm. On the same date same date and place, tell me if this is what you did. That you did willfully, unlawfully, and knowingly use force or violence upon the person of another, to wit, Jay Cobralda, who is performing the duties of a peace officer employed with the Las Vegas Metropolitan Police Department, which you knew or should have known that Jay Cobralda was an officer by punching and or kicking and or pushing the officer, such acts resulting in substantial bodily harm. Did you do that, sir?
Yes.
Okay. With respect to count 5, at the same date, place, and time, tell me if this is what you did. That count 5, performance of act or neglect of duty in willful or wanton disregard of safety of persons or property resulting in substantial bodily harm or death. That you did then and there unlawfully, willfully, unlawfully, feloniously perform an act in willful or wanton disregard of the safety of persons or property in the following manner, to wit, by jumping over the defense counsel's table into the well of the courtroom, thereafter rushing at the judicial bench and leaping over it Superman style to attack and or kill the judge, causing Marshal S. Brandon and others to respond in defense of your actions towards the judge, resulting in substantial bodily harm or death to Marshal S. Brandon. Did you do that, sir?
Yes.
Okay. With respect to count 6, battery by prisoner, on the same date and place and time. Tell me if this is what you did. That you did willfully, unlawfully, feloniously, and knowingly use force or violence upon the person of another, to wit, Officer C. Boo, by spitting on Officer C. Boo, defendant, you at the time of the offense being a prisoner in lawful custody or confinement. Did you do that, sir?
Yes.
With respect to count 7, on the same date and place, and the act being unlawful act relating to human excrement or bodily fluid, tell me if this is what you did. That you did then and there, willfully, unlawfully, feloniously, and intentionally use, propel, discharge, or spread any human excrement or bodily fluid consisting of saliva with the intent to have the excrement or bodily fluid come into physical contact with any portion of the body of another person, or under circumstances in which the excrement or bodily fluid was reasonably likely to have come into contact with any portion of the body of another person, to wit, Officer C. Boo, whether or not such contact actually occurred while you were a prisoner in lawful confinement, you committing the offense in the following manner, to wit, by spitting saliva on Officer Boo. Did you do that, sir?
Yes.
Okay. And for that reason, you are pleading guilty to committing the crimes by pleading guilty but mentally ill to committing the crimes of count 1, attempt murder, victim 60 years of age or older, a category B felony in violation of NRS 200.010, NRS 200.030, NRS 193.153, and NRS 193.167. Count 2, battery on a protected person, resulting in substantial bodily harm, victim over 60 years of age or older, a Category B felony, in violation of NRS 200.481. Count 3, intimidating public officer, a Category C felony, in violation of NRS 199.300. Count 4, battery on an officer resulting in substantial bodily harm, a Category B felony in violation of NRS 200.481. Count 5? Is that what I'm on? Count 5, performance of act or neglect of duty in willful or wanton disregard of safety of persons or property resulting in substantial bodily harm or death, a Category C felony in violation of NRS 202.595. Count 6, battery by prisoner, a Category B felony in violation of NRS 200.481 2F, and count 7, unlawful act relating to human excrement or bodily fluid, Category B felony, in violation of NRS 212.189. Is that right, sir?
Yes.
Okay. Is the state satisfied with that canvass?
Yes, Your Honor.
Okay. At this time, I am going to allow Mr. Redden to withdraw his original guilty pleas to counts 2 through 7, and it is the finding of the court the defendant is fully competent and capable of entering an informed plea with respect to the 7 counts, and that your plea of guilty but mentally ill is a knowing and voluntary plea supported by an independent basis in fact, containing the essential elements of the offense charged, and for that reason this court accepts your guilty pleas. We need to give this gentleman a sentencing date.
Yes, and I believe the defense counsel was requesting 60 days.
Yes, Your Honor.
60 days?
Yes, Your Honor.
I think we can accommodate that.
Court's indulgence, Your Honor.
Sure.
Judge, just for the record, was the Mr. Arnold's acknowledgement attached to the guilty plea agreement?
I've got it. Yes.
Just wanted to make
Certificate
sure.
of counsel?
Yes,
It's there.
thank you.
Okay, and go ahead.
November the 7th, would you like a special time, Your Honor?
Do you want a special time?
Yes, please.
Usually I have my calendar at 8:30. Do you want to do it after? Or do you want to do it in the afternoon?
We can do 10:30 or 11, or we can do the afternoon, whatever. So afternoon would be better.
Oh, now this shouldn't be a Wednesday.
No. I'm saying on the Thursday.
Okay. Yeah, because I have gotten where I just don't settle on. There's just no way I can get it done. Right now, we've got 6 criminal sessions on that. I could probably do it at noon if you want to just do it at noon.
Whatever Mr. Arnold's preference is.
That's fine, no.
Okay. We'll just take a later lunch, okay?
November the 7th at noon.
Thank you, Your Honor.
Thank you.
Okay, thank you. And Ms. Clerk, I'd like these documents, Dr. Paglini's report, left side filed, as well as Leo Rowley, Dr. Leo Rowley's report, left side filed. Okay? Okay, and thank you very much. Well, wait, Mr. Arnold, do you want to take the defendant out now? I was going to tell the jury.
Oh, yeah, we don't need him here.
Yeah.
You don't need him?
No, no, you-
Okay. All right. Are you ready for me to invite the jury in?
Yes, sir.
Okay. Yeah, attach a copy. That'd be great. Sure.